Great, there we go. Okay. Carrie Colonisi.
Here.
Great. James Anderson. Gary Bass. Emily Bremer.
Here.
Thank you. Ilona Cohen.
Here.
Thank you. Peter Constantine. Stephen Crowley. Kurti Dotla.
Here.
Thank you. Elizabeth Dickinson. Neil Eisner.
I'm here.
Great, thank you. Andrew Emery. Don't see him yet. Cynthia Farina. Michael Hertz. Richard Hippolyte. Sally Katzen. Katia Krutel. Debbie Murphy, alternate for Daniel Liebman. Don't see her yet. Hillary Malawar. Jerry Mashaw.
Here.
I don't know if I said your last name right. I apologize. Randolph May. Nina Mendelson. Elena Ness, alternate for Rebecca Orban.
Good afternoon, I'm here.
Thank you. Nicholas Perillo.
Here, I apologize. I have to leave to teach at 1:15.
Okay, thank you. Richard Pierce. Don't see him yet. Mitchell Plav. David Pritzker.
I'm here.
Great, thank you. Teresa Wynn Roseborough. Virtual Ross. Noel Green, alternate for Helen Saracio.
Here.
Great, thank you. Lon Smith.
Here.
Great, thank you. Kevin Stack. Robert Stone. Thomas Sussman. Miriam Vincent.
Here.
Great, thank you. Adam White. Okay, is there anybody from the Committee on Rulemaking whose name I did not call or who was not present when I called their name that is here now?
Yes, Dick Pierce.
Great, thank you, Dick. I have you down. Was there somebody else? No, okay. Great, and then I just want to note that Bridget Dooling is a member of ACUS. She's not on the Rulemaking Committee, but for purposes of the Contractors and Rulemaking project, she will only be participating as the project consultant. Next, I'm just going to call the roll for ACUS members that are not on the committee, but who are in attendance. Again, if you could just unmute yourself and say here, that would be great. So Bridget Dooling, our consultant.
I'm here.
Great, thank you. And Rachel Potter, our other consultant.
Here.
Great, thank you. Susan Minson, alternate for Steph Tatham. Don't see you yet. And Jeff Leppert.
I'm here. Sorry, Susan.
Hi, Susan. Thank you. Jeff Leppers.
I'm here.
Great. Are there any other ACUS members, either on the Committee on Rulemaking or just regular ACUS members that I did not call?
Yeah, Mitch Plave here.
Oh, Mitch Plate. Okay, I have you down. Thank you so much. Okay, I think that's it. So I'm going to turn it over to Carrie to get started. Thank you, everybody.
Thank you very much, Kasia. Appreciate it. The second meeting now of the Rulemaking Committee will be coming to order to consider the possibility of a recommendation to move forward on contractors in rulemaking. just at the outset, a few reminders about our standard meeting protocols. Only ACUS members, and that includes government members, public members, senior fellows, liaison representatives, and special counsels, whether on the committee or not, and their designated alternates have full speaking privileges. Now, to minimize background noise, though, I would ask that everybody keep your microphone on mute when you're not speaking, and then either use the Zoom hand raise feature, or if you can't use that, put a comment in the chat feature if you'd like to speak. And then I'll call on you and you can unmute yourself at that time and then remute yourself when you're finished. I would ask that ACUS members and their designated alternates keep your webcam on, and that will help facilitate a conversation. With respect to any meeting attendees other than ACUS members and their alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll then consider calling on such attendees at appropriate points. And absent some objection, I will assume we have unanimous consent. In the interest of time, I also may limit the length of any of such comments. If any such participant who's not an ACUS member would like to speak, you can also please indicate that by raising the Zoom hand function or putting a note in the chat, and then wait to speak until I call on you. And then you could unmute yourself and remute yourself just as with ACUS members. Do want to ask all participants to reserve the chat feature only to indicate that you'd like to speak, or should we get to the end today and be ready to take a vote for a purpose of voting. Would urge you to avoid sidebar discussions or substantive comments in the chat function. Let's use our hand raise function and speak to each other when we have comments to share. At the end of today's meeting, again, if we are at that point, we would have a vote, and only members of the rulemaking committee would participate in voting, and we'll go through that if we get to that at the end, which I hope springs eternal. We may well be there. I'd like to, with that, ask if Matt Weiner has any opening comments that he would like to share, and then we will get underway with the committee. Matt, is there anything you would like to offer at the beginning?
I do not, but thank you for asking, Kerry.
Okay, great. I'd like to open up our discussion today with just to invite any general comments from our membership, if you have any, about the preamble or the overall project. I want to thank the ACUS staff for their terrific work, Kasia in particular, on the drafting of a preamble, which, as you recall, had only been sketched out at our last meeting. I don't want to delve too much into wordsmithing in the preamble just yet. I think it's probably more productive to wait until we have settled on language in the recommendation before getting to finer points in the preamble. But since we do have a preamble now to look at, I think it would be helpful, or at least I'm open to any general comments or questions that might be prompted by the preamble. Again, reserving in a little bit later, after we make our way through the recommendations, any particular comments about very specific wording in the preamble. So let me first invite, if there are any general comments or questions that the members of the committee would like to share, we'll do that. If none, then let's wade into the to the draft recommendation itself. Okay, seeing no general comments then on prompted by the preamble, I'd like to ask if we can, Kasia, if we could display the recommendation and take a look at what is outlined as paragraph 1, starting on line 51. Just by way of background, the numbering has shifted a bit from our last meeting. What had been number 1, as you may recall from the last meeting, has been now incorporated into the preamble. So we are at new number 1, which begins with this recommendation that agencies should adopt, disseminate internally, and consider publishing on their websites policies relating to the use of contractors to perform rulemaking related functions. And then these policies could cover matters such as are outlined in subparagraphs A through E. I will note for everybody's attention that we did flag in here a question given some of the discussion from last meeting about whether this might in subparagraph A say anything related to functions or tasks related to drafting in particular. But I invite comments, questions on any aspect of what is identified here as paragraph 1. I guess it's line 50 on what Kasia is displaying. Jerry?
Sorry, I had trouble unmuting there, Karen.
That's fine.
In 1, we say that agencies should adopt and disseminate internally and consider publishing on their websites. I'm having difficulty imagining why an agency would not publish it on their website, and indeed have a question about whether it might even be required by the Federal Register Act.
It's a good question. Would that counsel in the last point about whether it's already required suggest that consider publishing on their websites is superfluous, that we should remove that language, or perhaps it should give the committee reason to simply say publish? So I don't put that out there for anybody to react to. And I have Emily next. I don't know if you're going to respond directly on Jerry's point, but
yeah,
feel
I was
free.
actually just going to say that if we think it's superfluous, and I that's a question I have too. I share Jerry's question. Then I think we should also get rid of disseminate internally, because if we keep disseminate internally and get rid of the reference to publishing on their websites, I think that implies that the only dissemination we anticipate is internal.
Okay, so the suggestion, I take it from Emily, would be to revise this so it says agencies should adopt written policies, right? Would go directly to that and could delete everything in between adopt and written policies would be what I take Emily to be suggesting. It's next we have Miriam.
Yeah, so I agree with Emily. The publishing whether or not it's required under the Federal Register Act depends a lot on how the agency decides to draft and interpret what they're actually doing. So it may or may not be required to be published in the Federal Register, but I think just the fact that it's being adopted, then if it falls under the Federal Register Act, then they have to publish. If it doesn't, they don't have to, but they still can. There's nothing that would prohibit them from publishing. And there's nothing then that prohibits them from actually making it public in any other way with this language.
Okay, thank you, Miriam. So you would support this amendment as well that Emily has suggested? Yeah. Okay, great. Thank you. David Pritzker.
I agree with the objection to the original language, but I don't get why we don't, as a matter of good government and transparency, say agencies should adopt and publish written policies, particularly after hearing what Miriam said, that maybe it is, sometimes it isn't. I think we ought to be on the side of open government and say agencies should adopt and publish.
Okay. Any comments on David's suggestion now to insert and publish between adopt and written? Okay. So I take it there are no other comments then or questions about the opening line. Jeff, go ahead.
Yes, I'm sorry I missed the first meeting, so maybe you discussed this, but I'm focusing on the words rulemaking related functions. You probably spent some time talking about that, and it comes up again later in number 8 in terms of making notation in the rulemaking record. But the definition of rulemaking related functions could be pretty broad. I mean, it could cover somebody who's just helping out with the IT aspects of it or something like that. So I think in number 8, we would definitely want to make a change to say something like policy related functions in rulemaking. But here, where we're speaking really broadly, I'm just wondering if we can narrow it a little bit so we're not covering contractors that work at the agency and happen to be working on a rulemaking because they have IT responsibilities, something like that. And so while I have the floor, I just on 1A, I think we should spell out IGFs first time we use it in the recommendation as well.
Okay, thank you, Jeff. I as to the point about just having an IT person, for example, helping some agency employee who's working on a rulemaking with that person's computer, presumably that could be
an editor, even something like
right.
that.
Yeah, I mean I guess my own take on this would be that the agency has the flexibility as one is currently drafted to resolve that however the agency sees fit, but that they should address something related to the use of contractors, and they may well in their written policy then I think be well advised by you and and I think by themselves probably to realize that it need not necessarily apply to the IT vendor or something like that. But I'm open to if anybody has any further response either from our last meeting or any fresh perspectives on this. Okay. Are there any other comments or questions about any of the subparts of paragraph 1? Okay. So I'm seeing no, and Jeff, you have your hand raised, but I think that's still from left over from the last time, I'm assuming. Okay. Emily.
Yeah, so I guess I'm going to raise the issue that was in the comment bubble, if this is an okay time to do that.
Sure.
So for those who are not at the meeting last time, we had some discussion about whether it's appropriate for agencies to use contractors to draft regulatory text and preambles, and I am personally, my view is that that is too close to, or is actually an inherently governmental function, because I do not see how you can disentangle the drafting of regulatory text from policymaking, and you know. So I continue to think that we should address this issue. It strikes me as the most potentially difficult issue that this recommendation raises. And at the moment, I think we're primarily recommending that agencies follow the law, which I think is good advice, but I'm not sure what value it adds. Whereas I think that we should seriously consider whether, you know, the current structure erroneously classifies drafting of rules that have the force of law as something that should be classified as inherently governmental, and that agencies should treat as inherently governmental. So I'd like to, you know, I don't want to spend too much time repeating views I expressed at the last meeting, especially if there's not anyone else on the committee who shares my concerns. But I would like, so I'm going to try to keep my mouth shut, and I hope that others on the committee might express their views, because I would like to, and I don't think this is necessarily a matter of internal management so much as it is a matter of how we understand inherently governmental functions.
Okay, well, certainly we are open to hearing any views from ACUS members or committee members on this point as well. So Dick Pierce, if you are able to put your camera on, that would be appreciated.
Well, since I just finished class and I'm in the middle of a peanut butter and jelly sandwich, that might not be appreciated by everyone, but I can do it if you want.
Yeah, that's fine. That's fine. Yeah, no, I will. What's a peanut butter sandwich between friends, Dick?
Okay, well, it's kind of a messy one, but it is, tastes good. So I'm strongly opposed to that. You know, drafting. Well, let me put it in concrete terms. If it hadn't been for the consultant that the dean made us hire to come up with this strategic plan, we'd be in year 8 of getting nowhere. What we have is a 35-page document now that I am confident is going to be, well, I know it's going to be approved by the faculty. I think it's going to be approved unanimously, where the last step in the drafting is 100% done by the members of the committee. But the first step in the drafting was 90% done by the consultants. This is a way you get things done. If you don't have the consultants beating you about the head and shoulders and saying, here's language, chew on it, tell me what you dislike. In many cases, you're just not going to get it done. And frankly, law faculties and agency staffs are not dissimilar animals. And I think in many cases, if you don't have a fair amount of involvement of a contractor in the drafting process, you don't get the job done. or you get it done in 10 years instead of a few months.
Thank you, Dick. And obviously, the general point about having the ability to work off of a first draft is something that applies. Now, who drafts the first draft in Supreme Court opinions? Not that usually the justices, but or who makes the first draft on I've been on National Academy of Sciences committees. The staff will be helping with that. So certainly, then the question would be, is there something inherently governmental or problematic about that first draft, perhaps in the rulemaking context, being assisted by or created even at the outset by a contractor? Nick Perillo.
Thanks. I just wanted to invite the consultants, if they wish, to highlight for us anything they've observed that they consider especially relevant to this question, which is not to say that I'm asking the consultants to come to a conclusion about it, and I'm also not saying that the committee could not, on the basis of its own experience and its own views, come to a conclusion about this independently of the consultants. But I just do want to invite them to highlight anything they consider especially relevant on this.
Fair point, and I don't see anybody else in the queue. So Bridget or Rachel, was there anything that you heard or learned that you want to share with us at this point, about this point?
Sure, I can just make a comment, which is that when we heard about regulatory text drafting or preamble drafting, it was often in sort of this more technical context where the agency was really specialized with, say, engineers, and they had, that's where the consultants were really helpful, because we are not good writers, is what we heard several times. And so that was just some context and background of why an agency might do this, is they literally don't have the staff. Now, our report comes up with other ways, if we think this is IGF, that an agency could get that help. So there are governmental means like rotations or things like that they could do. The other point I'll make is that, and I think Emily had referenced this last time in her comments, was just looking at the OMB guidance and trying to understand why legislative drafting is carved out as IGF, but regulatory drafting is different, is a puzzle worth, I think, unpacking and trying to figure out if there are substantive differences that we care about here or not. So I'll stop there, and maybe Bridget has a few comments to add as well.
Yeah, I think just building on that last point, and thanks, Nick, for the invitation, and Carrie, to speak on this point. After our last meeting, we went back through the US Code just to see where else inherently governmental function might be referenced, and did find that with respect to performance plans, I might get the statute wrong, but I think this was part of the GIPRA Modernization Act. There was a provision inserted in that legislation to say that when it comes to writing strategic and performance plans, that task of drafting those is considered inherently governmental. So I raised that also because now we've got legislative drafting and we've got strategic plan and performance plan drafting that's considered inherently governmental. And then we found one other substantive provision that seemed very specific to a program. It begs the question, what happened there? Because it sort of says this program, anytime it does economic analysis, that is considered inherently governmental, and therefore shall not be handed to a contractor. So there are at least a couple more instances of this where Congress has waded into the question of what's inherently governmental. And so I do think that's additional information that we weren't able to share at the last meeting that's worthy of consideration. Just the idea that the boundary line of what's inherently governmental is, to some extent up for grabs, especially as we learn more about, how these functions are playing out in practice.
Okay, thank you. So are there any other comments? I would just, say as this is currently drafted, it does leave it up to the agency. There's nothing in this that would preclude an agency from specifying that drafting in its context would be considered inherently governmental. Emily?
So one other thing that I recall seeing in the report, and the consultants can correct me if I'm misremembering, was that some of the folks who were interviewed actually said that they don't give drafting to contractors because they view it as inappropriate. So one thing I will say is I think the report suggests that there are agencies that share the intuition that I've expressed. And then the only other thing I'll say is I thought a lot about this this sort of rationale for why agencies would want a contractor, especially to write, like the first draft of a regulation. And I guess the concern I have is sort of twofold. One is that if you're not good at writing, to use the language that Rachel just offered, why do you think you're good at reading? Like how, if you don't think you can write the policy you want into the law, why do you, or into the regulation, why is there confidence that you can read what a contractor has written and discern what policy choices have been made? And then the second issue is that, if you have a contractor do it, then that's experience and expertise that isn't learned by the agency and doesn't stay in the agency, which of course will be responsible for, interpreting those regulations, applying those regulations, possibly defending them in court. The Supreme Court has recognized in Kaiser that a big reason for giving deference to agency regulations is because agencies write those regulations. And so I think there are some, other considerations there that are also worth considering.
On your rhetorical question, Emily, I would just say that I can read a Shakespearean sonnet, but I can't write one, right? Anyway, David.
Forgive me for repeating something I said at the last meeting, but it's pertinent to this issue. I have no problem with 1A as written now, but I've raised the question that it certainly would not be unheard of in the case of negotiated rulemaking for a facilitator of the negotiation committee under contract with the agency as part of the facilitator's responsibility to help the committee members reach a consensus, might do some drafting and offer it to the committee. In separate comment on Emily's last point, I would question whether it's the writing or the approval of the language. I don't see a problem if someone else writes it, but the agency ultimately decides to approve it.
Okay, David, and that's certainly a comment here where ACUS has in the past taken positions supportive of negotiated rulemaking, and what implication would a drafting ban have for that practice?
Well, one way for us to handle this now is to leave that issue within the scope of an agency implementing recommendation 1A.
Okay, thank you. Bridget, your hand is up again.
Yeah,
Did
sorry.
you want to have further comment?
Yeah, there was one more thing from the report that I wanted to raise for you all, and that's that I actually don't remember if we talked about this in the report, and if not, we can add it if you think it's useful. But there were some agencies that have like a centralized group of reg writers. So that was another way of solving that, like specialized knowledge, right? Like how do you help the engineers or scientists or folks who, are not as steeped in the regulatory writing process? The answer isn't necessarily contracted out, right? Some agencies have chosen to keep that work in-house and have a crew of regulatory writers who are on staff who can help with whatever the rulemaking projects are of the day. And I do think that is more in line with the drafting analogy that you raised, Carrie, to like who's writing the first draft of a Supreme Court opinion. because it's part of the court's staff, right? It's not an outside entity with their own interests that may or may not have been disclosed. In the case of a clerk, writing a draft, you certainly always have principal agent problems, but you don't necessarily have those conflicts issues that we have identified in the report.
Well, I think the conflicts issues, though, would apply with any kind of task, right? I mean, it's not just with drafting, right?
For sure. It's just a question
Yeah.
of how those conflicts
Right.
could manifest,
Right.
right? If drafting poses, I think it's not wild to say that drafting poses a greater exposure to those risks than does making copies or providing courier services, right? So that's what the combination of the risk and the type of task seems relevant.
Okay, thank you. Elena?
Hi, I'm just getting my video on here and I think I just clicked it twice. Okay, looks like I'm on. And I think this actually works out well with what Bridget just said, because actually my role at the Coast Guard is a regulatory attorney. And so helping with the regulatory drafting and supporting the engineers, which is why I put my hand up, is part of my job, but I can sort of confirm that engineers not always good at writing. They are actually pretty good at reading, right? Like if I can get them to tell me, I read what they've written and I ask a bunch of questions and sort of write it back to them, they can tell me if I've accurately sort of disseminated what's really important in the message they're trying to get across. They're not good at communicating that up front. I'm also generalizing a lot because some of them are pretty good at that. But so I think that is, something that I don't really have a concern there. I do agree with the other comments. I think that A as written is fine. I think if we're going to impose additional suggestions, then we need to talk about what that really means. Like, what do we mean by drafting? And then we could potentially get really deep in the weeds that could potentially complicate matters a lot. So that's just something to think about, but just wanted to chime in about engineers.
Yeah, thank you.
and the way that I have to sort of help clarify language in the interest of things that can be understood by the general public and our OIRA reviewers. That's always really important. We want them to be able to understand what you've put in the document.
Great, appreciate that perspective a lot. Back to you, Nick.
Thanks. I know we're not on the preamble yet, but would it be okay to look at the language that's now in the preamble regarding drafting? Because I mean, as this whole document is currently drafted, it's not as if we plan to say nothing about drafting. There is a plan to say something in the preamble, and perhaps that should be considered jointly with the recommendation text.
Well, let's take a what would you like us to look at in that regard, Nick?
I believe it's on the second page of the document. There's a couple of sentences in there now about drafting and risks regarding IGFs.
Yeah, so yeah. So Nick, do you want to flag that?
Well, I mean, it seems to me
just to say that we've already, in some sense, addressed this, at least normatively in the preamble, that this could be a heightened risk, and that may be sufficient.
Right. I mean, we're flagging a heightened risk without articulating a categorical principle. We're not saying nothing. I just want to bring that to everyone's attention.
Okay, great. Appreciate that. And obviously, if we think that something in that passage of the preamble might be worded differently, we could come back to and start wordsmithing, but it is worth flagging that is there. And I appreciate that very much. Jeff, you're next.
Yes, on Nick's point, and on line 23 that's up there now, the word support is really the key word. It almost should be italicized. Those that provide support for the agency's policymaking and do not supplant the agency's decision making. So I think that's one of the things we've been talking about. But I also wanted to bring your attention. I haven't seen any reference to this, but ACUS has an old recommendation from '85 on Tom McGarrity's report on agency procedures for performing regulatory analysis. And there's a paragraph in there, paragraph 6. This is 85, recommendation 85.2, which I'm just going to read quickly. It says, it's titled Use of Consultants in Preparing Regulatory Analysis Documents. Agencies can benefit from entering into consulting contracts with qualified experts to aid in gathering and analyzing information for regulatory analysis documents. However, agency personnel should retain the ultimate responsibility for the contents of regulatory analysis documents and guard against consultant conflict of interest. To these ends, agencies should ensure that 1, agency employees, not consultants, draft regulatory analysis documents. And 2, when a regulatory analysis document relies on consultant reports, the reports are placed in the public file of the rulemaking proceeding, even if FOIA's exemption 5 might apply to portions of the report. So we've covered some of this ground already with respect to the more narrow issue of preparing and drafting RIAs. Some of those, the way it came out is similar to the way we're coming out, although it does stake out a more clear position on they shouldn't draft. And that brings up the question again of what does draft mean? Is it first draft or signing off on the final draft? So I just wanted to throw that into the discussion. I generally agree with the comments of Dick Pearson and David Pritzker that we should kind of leave it up to the agency to decide the best way to come up with the final product, the final draft, but it should be the agency that makes the decision itself on the words of the final draft.
Okay, so thank you very much, Jeff. Appreciate that. And in your bottom line then is the way, if we can should go back to paragraph 1 in the recommendation, that wording in 1A would allow the agency then to make that determination. You think we've got what we need pretty much there?
Yes.
Okay. All right. Well, I'm not seeing any other comments, and I'm not hearing anything proposed to change. Open to any further discussion of this. I think it's been important to flag this and air these issues, and we can return certainly to any wording changes, or maybe adding a footnote to the recommendation from 1985 that Jeff mentioned in the preamble on this point. But at this juncture, are there any further comments on 1A or any other aspect of recommendation 1? Bridget?
Just a clarification for Jeff. Thank you so much for pulling up that draft recommendation. That's really helpful, and we'll definitely make references to it in the report as well. Thank you so much for that. And when you were saying that you're comfortable if it's left to the agency's decision, do you mean comfortable leaving the question of whether and how contractors are involved in drafting, that's what you're comfortable leaving to the agencies, or you're comfortable leaving to them something else? I got a little lost.
Yes, I think I am comfortable with what you just said, as long as it's the agency that makes the final call on the draft, on the final draft.
Okay, so that would be moving away from that recommendation that you named, right? Because the recommendation said contractors shouldn't be involved in or shouldn't draft or something. But you're saying you are comfortable with them drafting as long as they don't hold the pen on the final version.
Yes, I think it's the word draft has several meanings, as was pointed out in the comment.
Okay.
And by the way,
thank you for that. Go ahead, Jeff.
By the way, you should look at Tom McGarrity's book on regulatory analysis, because I'm sure he discusses this more.
Okay, so ACUS member Curdy Datla.
Thanks. I had a question about 1C, I wasn't sure whether the intent of that recommendation was sort of coextensive with what we were editing in the first sentence of one about like just disclosing the general policy, or whether the intent was like for any given use of a contractor, it should be clear within the agency what the lines are so that they can be, you know, more easily policed on a project by project basis. So I was hoping that could be, somebody could clarify what the intent was there.
With respect to what the coverage of 1A would be?
1C.
1C. Oh, okay. I think this would, this could be either general requirements for internal disclosure, or it seems to me it encompasses also general requirements about when to give specific instructions about internal disclosure. The way it's worded, at least as I read it, can encompass both and give the agency a discretion in their written to develop a written policy that either lays down firm rules for internal disclosure across the board, or some general rules about when specific determinations about that should be made. I think that's, others may read that differently, so I'm open to further thoughts. Curdy, do you have a preference for one or the other? Do you have suggestions for how 1C might be revised?
I don't know that I have a preference. I think if it was meant to be, agencies should generally have rules about, you know, publishing internally what functions contractors update. I'm not sure I see how that's not already encompassed within agencies should adopt and publish written policies, that statement in one. But if it's about specific, you know, being clear in specific projects, that might be something additive. So I think that's where my confusion was coming from.
Right. So if I'm hearing you correctly, I mean, one possible response to what you're saying could be to add some words to 1C, requirements for internal disclosure with respect to specific rulemakings, or something like that.
Yes, I think that would at least address, that would make it clearer that it's adding something different than the general publication requirement in one.
Okay. I would take out, Kasia, the word concerning.
I might put that phrase at the very end. I think that would also solve the problem. But
yes,
totally
there you go. Okay, excellent, excellent. So move with regard to specific rulemakings to the very end before the semicolon, and then reinsert the concerning where it had been. Excellent. Any comments on that suggestion, or any other comments?
With regard to a specific rulemaking?
Or I would make it plural with respect to specific rulemakings, plural. Is that okay?
Yes.
Okay. Any concerns about or questions remaining about recommendation 1? Okay, hearing no other concerns, questions, suggestions about 1, let's move to number 2. And Kasia, I don't know if it's possible to just increase the size of things a bit, but still keep all of 2 on there. That might be helpful for everybody to see better. Good. Any comments or questions about number 2, which calls for training on inherently governmental functions and activities closely related to them, ethical restrictions, and then also designating an agency office or officer to answer questions about the use of contractors. Okay, Jerry? You're still muted, Jerry, just to let you know that.
Sorry. Since we're leaving to agencies the determination of what, for their purposes, are considered as IGFs, I wonder if we just shouldn't add in here training for managers on matters that the agency considers IGFs.
Okay. Okay. Any comments further on 2 or on Jerry's suggested addition to 2? Okay, so hearing and seeing no hands or raised, no other comments, let's move to 3.
Can I make a wording suggestion, please? I don't think the syntax is very good here because we have 2 ands in this sentence. My suggestion is to put a period on the last line of the page, line 65, put a period after contractors and put the next thought in a separate sentence. The agency should designate.
Agency should designate. Okay.
So
Yeah.
the first sentence we have should consider instead
Right.
of should designate.
You want to put also, agencies should also consider? All right, any concerns about that change or any other comments on 2 then? That satisfies you, David?
Yes.
Okay. All right, let's move to paragraph 3 then. Agencies that rely on contractors should ensure that agency employees can identify them and so forth. Jeff, you have your hand up on number 3 here.
Yes, just a small point, and it's maybe I can ask the consultants about this one, but the word use agency email addresses, when I read it, it sounded like that was something that was kind of something that was sort of a shady tactic on the part of the contractors. But when I read the report, it was, allowing agencies, allowing contractors to use agency email addresses was good for team building and so forth. So maybe just to change the tone a little bit to say, instead of use, say be provided agency email addresses.
Okay. I think that's consistent with what the intent of this was. So, and be provided agency email addresses. Yeah, great. Does that meet your concern, Jeff?
Yes.
Okay. And obviously invite any comments if anybody has it on that change, but it seems almost in the committee on style category. Elena?
Yes, I like that change because I actually found that a little bit confusing before. I wasn't sure if that was meant to be they should have them or they shouldn't have them. And I think for no other reason than like an IT security issue, you actually want them using their agency email address for agency related items. But I put my hand up because I take a bit of issue with the prior clause in lines 77 and 78, participate in meetings. You know, I think participate is potentially a little bit vague. I think the real concern is that we don't want contractors making substantive policy decisions, but participating in a meeting, I don't necessarily see that as problematic on its own. We use contractors, for example, to take meeting minutes in meetings where substantive policy is decided. And so I wouldn't want to lose that, which I think potentially could happen by saying they can't participate in a meeting. So whether there's some different phrasing or a different way to clarify, I think the real issue is we don't want contractors to make the substantive policy decision. I'm not sure that it really matters that they're present when that happens.
Would it address that concern if we said here, I'm just going to go from the beginning of the sentence here, agencies may need to address whether contractors should work in the same space as agency employees, comma, how they should participate in meetings?
Sure, I think that, yeah, I think that helps.
Or to what extent, or, and then after the next comma, or the email, and whether to be provided with.
And I guess potentially on the I guess sort of the first clause of that about working in the same space, is that vague as well? Do we want them to, or do we not want them to? Maybe
well, this is, yeah. I mean, it does say may, first of all, agencies may,
right.
May need to address. Maybe the need is a little too strong, but may choose to address. Would that help too?
Maybe just may address. I don't know.
May address, yeah. Just may address.
Yeah, I just mostly want to make sure we don't sort of eliminate the potential for what, at least in my agency, is often very administrative type of tasks.
Mm-hmm. And Kasia, what if that backslash there you might change to an or? How or what or to what extent? Does that?
Maybe even an and.
Or and, okay. All right. Does that look like it addresses your concern?
It does. Yep.
Lena? Okay. Okay. Any comments on the suggestions here that have responded to Elena's concerns, or any other comments or questions about recommendation
How about
3?
in the inserted text, how and to what extent they may participate in meetings?
It may, okay. Thank you. Okay, any final comments, any remaining comments or at all on 3? I see no one, so let's move to 4. This is about information sharing within and across agencies, whether databases or schedules and so forth. We'll take a minute if anybody wants to refresh themselves by reading that. Okay, Jeff?
I don't have a solution, but the word, I can understand encouraging greater coordination about existing rulemaking contracts, but encouraging greater efficiency about contracts. That seems a little bit awkward. Concerning. I mean, it's just the word about doesn't seem to go with efficiency. That's all. Maybe David can fix it.
Greater coordination about and efficiency within, or
regarding, concerning, or regarding. Or...
Greater coordination. Sure, there we go. Does that work, you think, Jeff?
It's better.
Or just even about? Would about work? Greater coordination and efficiency about? Or no, maybe concerning, maybe.
That's where we started.
Oh, is that where, oh, we started, okay. I think concerning is better, certainly. Open to other comments on 4. Okay, hearing none, and I think I'm taking Jeff, your hand is just still left over from the last round. Let's move to number 5, ethics. Jeff, new hand raised for 5. Okay.
Yes. When I first read this, my reaction was, are we talking about the entity, the contractor, or the person? And then I got to 6 and I said, oh, they're talking about the persons down there. But I just, when reading 5, the term any contractor, of course, could be, Mitre Corporation, or it could be John Smith. And so I don't know if there's something we can do with 5 to sort of foreshadow what we're going to talk about next in 6. But that was my little confusion when I read it the first time.
How about whether any organizational contractor may have an actual or perceived conflict of interest with its entity, or whether any organization serving as a contractor?
Yeah, that's definitely getting to my concern. I like that approach.
May have an actual perceived institutional conflict of interest. Would that perhaps then in 6 we could say focus more on the personal. So I don't know if that would help.
Yes.
We have some other hands raised here. So Noel from EPA, if it's possible to turn on your video, we would welcome that. Nice to see you.
Thank you. Nice to see you too, and everyone. So in terms of, so I'm not like an ethics attorney, but I just was wondering when I read through this particular recommendation, my understanding is that contractors, of course, are retained, I guess, consistent with the FAR, the Federal Acquisition Regulations. There's like a competitive process, I believe, where they have to like bid and then their bids are accepted and all of that good stuff. I'm just wondering if that process sort of, it comes with internal controls to sort of manage potential conflicts or appearance issues or what have you. Just asking the question, putting it out there for anyone else that may know more than I do. But just, wondering if there is sort of like an inherent control for that, how that may affect sort of the usefulness of this particular recommendation.
It's a good question, Noel. Appreciate it. Invite anybody who wants to share on that to jump into the queue. Maybe our consultants would have something that they'd like to add about that particular point. But Elena, you're next.
That was actually what I was going to mention. I'm not a contracting attorney nor am I an ethics attorney, but I have served as a contracting officer's representative, and this is covered by the Federal Acquisition Regulation. or at least in terms of more specifically number 6, personal conflicts of interest, but there are a lot of specific regulations in the contracting realm that govern ethics and contractors.
So I'm Carrie, I'm happy to jump in here because
And
you know,
Reeve also is in line too. Yeah, go ahead, Katja.
I was going to say he might be speaking to the same thing because we had looked this up as a background. So I'm happy to take this if that's what Reeve was looking to address.
Yeah.
Go for it, Katja. I'll jump in.
Sure. Yeah. So Elena's right about the FAR addressing both personal and organizational conflicts of interest. However, it doesn't really go far enough to address these particular concerns. When it comes to personal conflicts of interest, it really hones in on the use of contractors in other acquisition functions. It doesn't, specify any particularities for rulemaking at all. And similar with the organizational ones, it's very general. And so I think when we were preparing this kind of went a little bit step further than what the FAR currently has, and as it relates to rulemaking specifically.
Yeah, and I'm happy to elaborate on that. Thanks, Katja. One thing, correct me if I'm wrong, so I believe that's absolutely right with respect to personal conflicts of interest. Organizational conflicts, correct me if I'm wrong, there was a FAR rule proposed, I believe, on that, but I don't think it was ever finalized, to my understanding. Is that?
So there is the FAR Part 9 deals with organizational conflicts of interest, but it's very, very broad. And so you are right in that there was proposed legislation to amend that and to include this personal conflict of interest scope to organizational conflicts of interest, but it didn't get passed. So it was withdrawn. There is still an organizational conflict of interest part in the FAR, but it's even broader than the personal conflict of interest one. It doesn't cover as much.
Got it. So yeah, so I think the key distinction then is the one sort of Katja laid out, which is that, there are FAR provisions that are relevant. However, I believe that if I'm remembering correctly, they're limited to activities that are closely associated with government functions, many of the activities which we may be discussing here may fall into that category, but not necessarily all of which might. And so really these recommendations, or at least 6 and 7, are largely drawn from a previous ACUS recommendation, 2011-3, that applied to contractors more generally, and then we tried to tailor it to the rulemaking context specifically within this, both with that recommendation in mind, and then with those FAR provisions in mind. And the idea was to sort of supplement those to some extent and cover some things that may not be addressed, within the FAR. And then with respect to the previous ACUS recommendation, apply it specifically to the rulemaking context, whereas the previous recommendation was broader, applying to contracting more generally. So just by way of background, that's where that language comes from. And then 5, though we don't have a prior ACUS recommendation on organizational conflicts, with that too, we sort of tried to tailor the previous ACUS recommendation and sort of extend it to that area in the rulemaking context specifically.
Although I will say that in each of these, there's still plenty of, room for flexibility that the agency has, either to select another contractor or put in place appropriate protections, which seem to me to be appropriate. But Bridget, you're next.
Thanks. One thing to note on this is that one of the things that came up a fair bit was the shift, which is ongoing, to longer, broader contracting vehicles. So the contracting vehicle itself might say something like to provide program support services, period. So at the time when you're bidding on the contract and going through that front end vetting, if there is any, it wouldn't be with respect to a rulemaking on X necessarily, because the contract itself would not be drafted to say this is necessarily. I mean, you could have a narrow one, but the incentives in the procurement system are pushing agencies to these longer, bigger more umbrella style contracts to which they can issue an individual task order. So just to say this, to the extent that there is any screening on the front end for conflicts of interest, either organizational or personal, the shift to these bigger vehicles means that you don't necessarily know what conflicts you're screening for, if in fact the rulemaking content isn't made aware to the contractor until after the award. And at that point, we're not aware of any process that triggers the need to disclose for the first time or again any more relevant conflicts. So it's not like the things that federal employees are subject to, where if you start working on a new matter and you have a conflict, you need to disclose, right? That's the part that's simply missing for contractors.
Okay, thank you. Jeff?
I'll defer my suggestion until Rachel speaks.
Okay, Rachel, do you want to follow on this point?
I was just going to add that some agencies have gone to the FAR and added their own particular subparts that really address conflicts of interest, not about rulemaking, but like the EPA has language in the FAR for Superfund that really prevents what contractors can do in future in terms of organizational conflicts of interest. So if you get a Superfund contract, you might not be able to get certain types of EPA contracts in the future that conflict with that, or you might have to limit and disclose your organizational conflicts of interest. So all to say, like, some agencies have taken this in specific fields and really built on it and built up like an infrastructure. We're not aware of anyone who's done that with rulemaking. We're not really recommending that they do that per se here or in our report, but it is within the realm of possibility that an agency could kind of flesh this out in the way that the EPA has done in that case.
Okay, great. Appreciate that. Okay, Jeff, back to you then.
Yeah, I think then the solution is to put something in the preamble in the paragraph dealing with ethics, starting on line 30, saying something like, while the Federal Acquisition Regulation and agency supplementary regulations to the FAR address both organizational and personal conflicts of interest in general terms, they don't address the kind of conflict of interest that can arise in a rulemaking. Just something like that, and then a cite to the relevant FAR provisions. That's my suggestion.
What if, while we're at this, Kasia, if you can, maybe you can reduce the size a little bit so we could see the whole thing, but maybe just at the end of that sentence that you're starting with, there are nevertheless potential ethics related risks against which it must protect and which may not be addressed adequately under existing regulations, procurement regulations. Would that be along the line? We can go back and revisit it, but
and then you could drop the footnote there and just
yeah,
cite the relevant FAR provisions.
Right. With that, and if we can return when you're finished, Kasia, to paragraph 5, are there any other comments or questions? I know Noel and Elena, you had raised this question. Hearing now Kasia's and Reeves and from our consultants, do you have any further comments or questions, Elena?
I will just say I like Jeff's addition, and the conversation was helpful because I didn't take that from reading the recommendations. So I think that his insertion in the preamble sort of helps clarify what we're really trying to do here. One other comment, not necessarily specific to 5, although maybe generally, if we need to try to distinguish between the contractor as an organization, which I think is generally what we mean, most of the time we're not talking about specific people. They're intended to be sort of interchangeable within the contract. And I think the FAR uses the term covered employee, or is there some other way to refer to them specifically under 6, where we're getting into personal conflicts? That might be helpful. I don't feel strongly.
Yeah, so I'm in the same place. I have also appreciated the discussion in the context, and I don't have anything further either there.
Okay. Picking up on Elena's last point, and maybe shifting into 6, if there's other comments still on 5, we come, but they are some, maybe to make this distinction between the personal and organizational, would it make sense on 6 in that at the end of that first clause before the comma on line 94, to where there's a risk of personal conflict by an employee or of a contractor, or something like that. David, you're next.
I want to go back to the change that's already been made on line 87.
Mm-hmm.
The sentence begins with, when selecting contractors. The organization is not yet serving as a contractor.
Okay.
So there's a time problem. I suggest revising that to say, evaluate, the agency should evaluate whether any organization under consideration to serve as a contractor.
Okay, great. Thank you. Jeff, back to you. Or was that a leftover hand? Sorry. Okay. All right. So 5, 6, anything, or shall we move on to 7? Curdy, you're next. Maybe on 5 or 6.
Yeah, this is minor, but 5 says rulemaking related functions and 6 just says rulemaking functions. I assume that language should be the same in both 5 and 6, the first line of both. So I think it should be rulemaking related.
Related functions, you're right. And there's also in 6, by the way, later on, which I think may, it's in 5 too. With any assigned task or function, we introduce here in 5. Everywhere else, the draft says function. I'm not sure it helps to start adding task in. It's also in 6. It says functions or tasks. Should we just keep it functions? Elena?
I'm not sure it really matters, but tasks are specific things under a contract. Was it Kazia who was mentioning the move towards umbrella type contracts where there might be multiple tasks awarded under a contract? And so that may be something that's important to distinguish, or maybe it just doesn't matter because there's still functions that you perform under a task. But I just wanted to mention that tasks is something that can have specific meaning in the contracting context.
I think that's very helpful. A question it would raise for me is then whether, if it is important to have it here, maybe it's important to have it everywhere.
Yeah.
So and that's my main point, is not so much whether we should have task or not, but we should be consistent probably throughout. And that could be given over to a committee on style if we think that there is an important distinction and we should have both tasks and functions mentioned, and we should just go through and make that consistent throughout. Or if it's sufficient to just keep it as function. I think this is about these are the only ones where that task or function language, at least I noticed in reading through it. So the easiest thing from the standpoint of consistency would be just to eliminate it here, but open to committee members' input on that. And Jeff, your hand is up I think a
Yes,
new.
yes, on the issue you just raised. So in 5 and 6, we're talking about assigned tasks or functions. And in the other ones, although I see in number 3, we say assigned duties. Maybe we should say assigned tasks there. But so if task is a term of art in contracting where there's an assignment of a task that is within the broader function, I don't have a problem with just saying assigned task in number 5 and 6 and not saying it's, just leave function in the first line and just say assigned task in the later line. And then in number 3, change duties to tasks.
If we go back to 3, I mean, should it be assigned duties or functions there? I mean, or assigned tasks or function?
I guess I defer to the contracting experts, whether the term tasks is a term of art that kind of fits within the broader idea of a function.
And even if it does, though, Jeff, I guess the question I would have is, do we really intend for in 3 for things to be just limited to assigned tasks, or could we again say there assigned tasks or functions?
Yeah. I don't feel
I mean,
I agree we should be consistent though.
Yeah, that's. And elsewhere, I will say, by the way, there's elsewhere, and it's more in the preamble, I think, we refer to rulemaking related activities by contractors. Now, maybe in some contexts, that's the differences are all of this are fine, but it is a global issue. And maybe what we can do is put this for right now into a little parking lot, and we'll come back to how to make these terms consistent throughout. Rachel?
I was just gonna chime in and reiterate the point Bridget had made earlier about umbrella functions and like this movement that we saw a lot in talking to agencies towards having contractors do so many things throughout the rulemaking process. And tasks is, right, we talk about task orders in contracting. So we do want to be careful, but I want to make sure that we capture this idea that things kind of aren't just always discrete tasks. That's the sort of emerging nature of this, that it's often many tasks that aggregate together. So I guess that would be a vote for maybe calling it tasks and functions.
Okay. Okay, so let's come back to that point more fully. Let's see if we can continue on. I am not hearing any other comments about 5 or 6. Or back to you, Curdy.
Yeah, could I just ask the contractors to, I just want to make sure I understand the point that I think Bridget made earlier, which is that the current rules don't adequately address the potential for a conflict to arise in the course of especially one of these long-term contracts. And I just want to make sure I understand their views on whether 5 and 6 are sufficient to address the later arising conflicts versus a conflict that is obvious at the time of the contracting process.
Any comments from our consultants? I mean, I would just say to that point myself, Curdy, reading number 5, it says when selecting them for rulemaking related function, and maybe we should amend that to rulemaking related tasks or functions. But either way, that's selecting them for their use in rulemaking. That's how I read this. So 5, it seems to me, could be a continuous obligation, if you will, or recommendation that agencies, before you may have this already a predetermined contract with X corporation to be providing all sorts of general services for the agency, but when selecting that contractors to work on rulemaking related tasks or functions, consider whether any organization under consideration would have an organizational contract. It seems to me that 6 is a little bit more in the initial stage of creating the contract, because it says should include provisions in the contract and so forth. So I read 5 to be more of an ongoing guidance, whereas 6 is more oriented toward the creation of the initial contract. Bridget?
Yeah, I think it's a really good point. And I mean, you could consider amending 5 and 6 to refer to both, selecting a contractor initially and also, before issuing task orders to the contract, right? So you make clear that we're not so much talking about what they're doing, we're talking about the mechanics of how you contract, and that this is something you should be aware of, not just at the front end. So I do think that that's useful. I don't think I can wordsmith that on the fly, but the goal would be to shift from, to make clear that selecting contractors happens, at least twice, right? Once when you award the contract, and then also when you issue task orders to the contract. And I think you would probably do that for both, because the conflicts issue exists equally with respect to the organization and the people, right? My individual stock holdings might directly trigger a conflict once I know that I'm working on a rule about a particular medical device, for example, in a way that if I just knew I was working with FDA, I wouldn't necessarily know, which of my individual stock holdings was the trigger. So I think that the conflicts trigger exists both organizationally and personally. And I think it's something to consider playing around with, shifting the structure of 5 and 6 to talk about, the decision points that the government has. Issue the contract initially, and then put a task order to that contract.
Okay, and we can come back to this if people would, think that we should make some changes. We can talk about possible changes here. Jerry?
Gary, I was just going to suggest that maybe it would solve it just to say when selecting and managing contractors for rulemaking related functions, so that we have the ongoing time element in there.
Okay.
Yeah, I'll just
maybe
add a little color here, if I may, while we're thinking about this. It was sort of interesting to hear both on the agency side and the small number of contractors that we talked to, like of the people that we talked to who were serving as contractors, which again was a very small N, we would say things like, did you ever have to disclose your anything about your personal financial situation, like your stock holdings or those of your spouse? And they all said, no. Who would we have given that to? So it again, small N, but enough for us to think like this doesn't appear to be systematic, such that if you're a contractor, and expect to disclose this type of thing, even upfront, right? Never mind on an ongoing basis as those conflicts are triggered. And so for us, that was a flag that like, okay, this seems like an area where there just is not any coverage.
Okay, Curdy.
Yeah, I wonder if one way to address this, in addition to selecting and managing, might be in line 89 to say when a potential organizational conflict arises or exists or arises, just to make that continuing obligation a little clearer.
Okay. Any other comments? Does this now meet with the committee's satisfaction? 5 and 6? Okay, shall we move on to 7 then? If you can display 7, Kasia, that'd be great. Okay, I'm seeing no hands raised. If there are no comments on 7, then let's take a look at 8. Jeff?
A comment on 7.
Oh, okay.
Rather than saying include provisions that provide.
Oh, David. Okay.
Include provisions in the contract requiring.
Okay. All right, hearing nothing else on 7. We'll move on to number 8 then. Jeff?
Okay, first, I just want to thank our excellent contractors for helping us draft this recommendation. Anyway.
We should be clear that these are definitely ACUS work product. If you look at the draft recommendations in the report, they are quite different from ours.
I know, but you helped us draft them.
You're involved in drafting right
yes.
now. I guess it's Jeff's point. Yes. Anyway, go ahead, Jeff.
Okay,
on number 8.
On number 8. So this is where I was worried about the the IT worker or the kind of generic consultant who was working on some piece of a rulemaking. So I was going to suggest saying when agencies use a contractor to perform a significant policy related function in a rulemaking, in a specific rulemaking, they should. Significant policy related function. So
okay, to perform a significant policy related function in a specific rulemaking.
Right.
Okay, so replace rulemaking related, significant policy making function.
Policy related function.
Or policy related. Okay, policy related function.
So just substitute.
Yeah, line 115, change rulemaking to policy. That anything else, Jeff?
No.
Okay, Curdy.
Yeah, so I have 2 comments. One is on this same language, and I just wondered if my concern was that we were introducing a term that we haven't really defined yet, like what a significant function is, but we do in the preamble use like a closely related IGF, or actually be closely related to an IGF, which I assume this is what this language is supposed to be a proxy for. So one suggestion would be to say to perform an activity closely related to an IGF, if we want to keep that consistent. And then the second comment was, now that I've seen recommendation 85.2, it does strike me as odd that we would have a much less strong recommendation about transparency related to actually writing the preamble and the regulatory text than the regulatory impact analysis. And so I wonder, I wasn't at the first meeting, and so I apologize for that, but I guess I'm wondering if there's if we could strengthen this language either to require disclosure or to require the disclosure of the contractor's initial draft, the way that recommendation 85.2 did.
So I take it you would want to say change consider noting to should note. I mean, is that the specific suggestion?
Maybe should identify the role of the contractor.
Okay.
I don't have any problem with identify, but I think substituting the IGF reference there just strikes me as too jargonistic. I mean, I think what we're really talking about is, policy making, or as the report indicated at some point, advice giving rather than, decision making. But I think it's really I think this, even if people go back and read the preamble to find out what an IGF is, it doesn't really map exactly with what my concern is, which is that the contractor is performing a policy related role. And
well, one possibility could be, Jeff, after the comma on line 116, to put something like either such as performing a significant policy
that would help
related, or including that, whatever that earlier language was, a policy related function
in a specific room. Yeah. They should identify the role. Yeah.
And maybe we should just say identify the contractor's role instead of I'm strunk and white, I don't know, get rid of the of and the.
I will point out that 85.2 does say, in terms of the disclosure, when a regulatory analysis document relies on consultant reports, the reports are placed in the public file of the rulemaking proceeding, should be placed in the public file. So
that's the law, right? But that if they're relying on anything, whether it's from a contractor or an article by Jeff Lubbers, it should go in the doc, right?
That's Portland cement, right? In a way.
Right. Curdy, I want to go back to you because you were raising this concern. Do you want to respond at all to these changes or make any other comments on 8?
Yeah, I think I'll just say in response to Jeff's point, I thought, I've only just skimmed 85.2, but I understood that recommendation to be trying to get rid of the deliberative process objection, to including that, just like an agency wouldn't include its own drafts in the rulemaking file. I took 85.2 to be saying, when it comes to contractors, we want that to be disclosed, even if it wouldn't be if it had been the agency's own work product. So I do think that's adding something distinct. But I don't want to, if this was already discussed, I don't want to relitigate or take too much time in discussing whether this recommendation should also, in addition to identifying the role, also identify the specific and disclose the specific document that the contractor provided. Unless others have the same concern I do.
Well, one thing that I will say that's different here is that 8 is not necessarily limited to a specific document per se, right? It could be, again, some participate, being in the Hamilton's phrase, in the room where it happens, I suppose. So certainly invite any other suggestions on 8 that anybody has. Rachel, you wanted to comment earlier, so I'll recognize you and then we'll turn to Emily.
Yeah, I was just going to point out that the language that Curdy suggested here about adding closely associated with an IGF is, so the definition of that we provide in the report from OFPP's policy letter says support for policy development, such as drafting policy documents and regulations, performing analyses, feasibility studies, and strategy options, which I think is what Jeff was trying to encompass. So I'm just wondering if that text where we say such as performing significant policy related functions, whether we might want to mirror that language from the policy letter or just actually cite to it. And I don't know if you do that in recommendations, but I think this idea is captured already.
Right.
And someone else has thought about how to sort of get at what this conversation is circling around.
Thank you. And maybe we don't put, well, there's some debate, I suppose, but typically ACUS doesn't put footnotes in the recommendations, but it certainly could be cited and even quoted if it's not already in the preamble. I guess I would just say that this inserting the clause that Jeff has suggested here, the such as performing, doesn't preclude in any way any of those other definitions of what is closely associated. In some sense, it's more expansive, I suppose, because it's different. And maybe that's a good thing, maybe it's a bad thing. I leave it to you all on the committee. Emily?
I think I like Rachel's suggestion, and I'm a little concerned about injecting at this point in the recommendation a new term. I mean, I'm not really sure what a policy related function is, and if we can address this issue as Rachel suggested with some citations and some reliance on the closely associated with an IGF language instead, I think that seems safer to me and less likely to raise questions. The other thing is, as originally drafted, it left quite a bit of discretion to the agency to determine the circumstances in which it would be appropriate to disclose this. And to me, that discretion is adequate to address the concern that I think initially motivated Jeff's point, which was that sometimes if someone, if a contractor is providing like IT support, it might not be worth making that transparent. I think the discretion vested in agencies by the language is adequate to address that. Yeah.
Jeff, before we delete that clause or anyone else, is there reason to keep it in there? I invite comment on that. David, you're next in the queue.
I didn't think they were going to delete it. I thought they were going to substitute the the other language that Rachel suggested. Okay,
we could do that. It's rather lengthy, but we could do that certainly. Or if it's cited and quoted in the preamble, will that be sufficient? And I guess that's a question just to keep in mind. Let me turn to David, I think you wanted to jump in on this point, David?
Not on that point, but on that sentence.
Okay, on the sentence. Anybody on this point first, and anybody else on this point, and I'll come back to you, David, on this sentence. Emily, on this?
Yeah, the last thing I was going to say is last meeting, because we have changed this to remove the discretion I referred to and to make it more categorical. And during our last meeting, the concern that was raised that I have not heard articulated yet today is that sometimes disclosure for disclosure's sake may raise unwarranted concerns about the use of contractors in a way that doesn't actually add information that's useful to people who are consuming the information. And so I just want to flag that we seem to have removed the discretion that I think we, for some decent reasons, had included last time.
Okay, so I mean, let me see if we can reach a resolution here, at least provisionally here. I'm going to suggest we delete the highlighted phrase you have there, Kasia, but let's add a comment to say that we will insert a footnote defining and including the full quoted language that Rachel had referred to earlier, which is rather lengthy, but we'll do that in a footnote in the preamble so it will be clear what closely associated with an IGF in a specific means. And I obviously invite comments on this. And then to address Emily's point, and this may be related to something that David wants to weigh in on too, and we'll turn to him next, would be to say, by the way, it should be not they, but it, because agency is singular in number 8. So it should consider identifying. Would that give the discretion, Emily, that you were calling attention to being missing? Okay, David, to you.
Well, actually, my point was precisely what you said. When agencies change to an agency, the they should also change it. But since there's so much other stuff going on between the reference to the agency and that pronoun, I suggest that you repeat the agency.
The agency instead of it. That's fine. Good.
I'll leave it to the staff to straighten out the A's and the ands in the sentence.
Right. Okay, Jeff?
Should it say when an agency uses a contractor? We're talking about things like the NPRM and you know, so I think it's throughout, right?
That seems appropriate. And then Kasia, if you could change it to the agency after the comma, yeah. Okay, any other comments on 8? All right, let's turn to 9 then. Any comments on 9? Okay, hearing none, then 10. Any comments on 10? Susan, any, just to ask if anybody from OMB is here, wants to weigh in on this, certainly welcome that. Curdy, though, you're in the queue on 10.
Yeah, so I think in line 127, we might consider repeating the phrase that we've used before, specific examples, that are closely associated with an IGF such that agencies should exercise heightened caution, just so we're using the same terms throughout.
Excellent. Okay, anybody else have any comments on 10? Jerry?
So, Carrie, I had a general sense of unease about 10.
Okay.
I don't know if any of you remember, about 15 years ago, the GAO was assigned the task of defining what an IGF was. They wrote a report that went on for 50 pages and didn't come close to defining it. Trying to assign OMB the task of telling agencies what IGFs are in their particular context, seems to me it might be not just an unwelcome task, but an undoable one.
Fair question, fair point. Since I invited comment from our member from ACUS member from OMB, Susan, please, would you like to weigh in? If you could turn the camera on, that'd be great. Thank you.
Sure. Thank you very much. I just wanted to say that I do want to circle back with our OFPP colleagues on this particular suggestion here, number 10. I was around in OFPP when they were developing the memo from about IGFs in the first place, and it is very challenging and complicated. So I just wanted to make sure that you're aware that I'm going to go back to our OFPP colleagues and make sure we get their input on this particular suggestion.
Anybody from ACUS staff have any insight in whether there has been any input at all, or because Susan's suggestion, which is certainly fair, it may mean that we're not able to, or may affect whether committees members want to approve this today or whether we go to a third meeting. All right.
I'll just, oh, sorry, Carrie. I was going to say that Steph Tatham had reviewed this before, and I know she's not in OFPP, but she is in OMB. So I defer to you on that one too.
Sure.
But
obviously, that's certainly totally fine, Susan, to take that view. It may be that affects the committee's views what to do today or not. I leave it to the committee we'll figure that out. Bridget, do you want to help us with anything with respect to 10 here?
It'd be my pleasure. So I'm certainly an OMB institutionalist. I sat in the OMB seat for many years at ACUS. And so in thinking about our own recommendation on this, and if you look at our report, what we encourage is for OMB to basically just be encouraged to take a look at the findings to decide whether they might want to update anything in light of it. I mean, when we started this project, we had no idea what we would find in terms of the tasks that contractors were helping for. In fact, we started as an Office of the Chairman project in part because we weren't sure that we'd have a whole lot to say on the other side of this, right? But we turned up a whole lot in terms of the way contractors are showing up in the rulemaking process. And so given that fact finding, which we believe to be the first ever on this scale, we thought it was appropriate to prompt OMB to just consider whether the way that they've drawn the line with respect to rulemaking, which is to say, put almost all of consultants' work into the, contractors' work into the closely associated category, whether they might want to rethink it for any of the types of tasks. So that was how we had framed it in the report. How much you lean into that and push them to do more is, of course, to the committee. All of this is to the committees for your determination. But we stopped short in our recommendations from telling OMB to update its guidance per se. We just wanted them to be aware of the factual findings, which we believe are novel, and to consider whether that might shift their thinking on how they're drawing the lines.
Thank you, Bridget. And in fact, that is how this draft is written. It's not telling OMB anything other than to consider assessing and then to consider whether it should provide further guidance for whatever that may be. Are there any other comments on 10? Seeing no other comments on 10, then I think we have pushed through for 2 hours very productively. We've finished going through all of the numbered paragraphs on 10. I'd like to suggest we take a break. It's now 6 minutes before 2, so we could get a 6-minute break, come back at 2 and discuss the point in the parking lot about the task or function language throughout all of the recommendations, and then anything related to the preamble when we return at 2 p.m. sharp. So let's start by taking a look at, and we can go paragraph by paragraph through the preamble. Let's see if anybody has any comments on any of these. I have one actually on the first paragraph. I'd like to strike the word often in line 3, because the consultant report doesn't really provide us with any frequency, ability to make any frequency conclusions. Are there any other comments on the first paragraph? Jeff?
Just a question. It starts off just by a neutral statement saying agencies rely on private contractors, whereas in the 85.2, it started off by saying agencies can benefit from entering into consulting contracts with experts, blah, blah, blah. And I'm just wondering whether we might want to say something a little more positive at the beginning.
Well, the end of the paragraph certainly is, although I would note on line 7, there's a missing E under increased staffing flexibility. I mean, this, so it builds
Okay.
up to it the way it's currently
All
structured.
right, I withdraw. That's true.
Okay. All right. Any other comments on the first paragraph? Second paragraph then?
Carrie,
here-
oh, I'm sorry.
Okay.
I have just 2 questions whenever you're ready on paragraph 2. If somebody else has something, I'll defer.
No, that's fine. I was just going to say one sort of typographical error, I think on line, maybe it's line 19 on the next page, top of them. I think provides, somewhere there's a provides with an S. It should be just provide without an S.
Looks like we lost line 19.
Or maybe we did. Yeah.
It just does that because of the track changes. When I accept it, it'll be a regular 9.
Okay.
Yeah.
All right. Is there a word provide? Well, there was on the draft that I saw, but
I see that.
I think, yeah, it was before that footnote, I think. Before footnote 2, there was a clause that's been somehow removed.
Which provides examples of certain IGFs
Right.
that should be contracted out.
Right. Yeah, I'm not sure. This doesn't match, Kasia,
Yeah,
what was
I see
circulated.
that. Yeah, I'm so sorry, everyone, but
So
otherwise we'll find
yeah.
it.
Why don't you, could you type that in, which provide
Yeah,
examples of certain IGFs, and just no S on the word provides. But with that, then Matt, you had 2 comments.
Let me I'll just share one of them. The other one might be just committee on style. Wondering about the phrase in line 13, exercise discretion in a way that avoids ethics concerns. Do you exercise discretion to avoid concerns, or is it problems or something? Concern strikes me as perhaps not the right word.
You could avoid raising concerns, I suppose, or you could just avoid problems. Maybe you're right.
If others think it's fine, it just stood out to me.
Maybe avoids raising ethics concerns. Would that work?
Yeah, I think it's okay. I'll withdraw the comment.
Okay. Did you have a second point?
I think it's a good comment. I mean, I think we don't want to avoid concerns over ethics. We want to avoid violations of the ethics rules. So I think avoids.
It avoids ethics violations or ethics problems. Okay, Matt, did you have a second point?
No, my next point is on the very last line of the preamble, so I will wait.
Okay. Emily, you've been waiting patiently on this second paragraph?
Thanks, Carrie. In line 15, I of course agree that agencies should follow Circular A76, but we usually don't use that kind of recommendation language in preambles. So I wonder if it should be just rephrased to identify the circular as opposed to,
How about if we just say, with respect to the prohibition on contracting out IGFs, the Office of Management Budget Circular provide examples of certain
Yeah.
And then just correct the spelling error in examples. That works for you, Emily? Okay, great. Jeff?
Yeah, this is a really small point, but in the footnote 1, other relevant legal considerations may be presented by statutes such as FACA. I'm not sure, I looked through the report and I didn't really see much about FACA. I'm not sure how FACA bears on the use of consultants exactly.
That sentence is responding to some discussion at the last committee meeting. Doesn't mean it needs to stay, but I'm just giving you the background of why it was there. There was some discussion, I think, by some committee members that FACA might be relevant.
I mean, maybe the contracting statutes would be more relevant there, but I didn't really see FACA as the best example of a statute that might affect all this.
We could eliminate the example and just maybe presented by other sources of law or something like that. May be presented as well. Other relevant legal considerations may be presented under other sources of law. And period, leave it at that.
Yeah,
I think the point also was not to imply that these are the only sources of
that's
law.
fine, but I just didn't think FACA was, unless there's something about FACA that really bears on this.
Noelle, do you want to reply on this point or anything else?
Sure. So this, I believe, was partially meant to address, I know that I raised a concern, I don't know if others had it, but just to kind of flag that there might be some FACA implications, just lessons learned from prior litigation that EPA has experienced surrounding the Bristol Bay Pebble mine and everything. And just, I had just flagged that, you know, plaintiffs in that case were able to make hay over the fact that we consulted multiple contractors in drafting or putting together the assessment that was then underlying a determination decision that was made in the challenge in 2014. So I think that was just a way to sort of address that. But, you know, I think it's fair to just say something a little more general if folks think that FACA in particular, and I don't disagree, right? That FACA in particular might not be as on point, but it's just a way to say that there might be other things that can control, or not even control, but just like to be mindful of when going through those processes.
So would you be okay, Noelle, with deleting the specific reference to FACA, but leaving something general like is in that footnote?
I'd be okay with that.
Okay, all right. Any other comments on this second paragraph? I might, Emily, by the way, not Emily, sorry. Emily was the first staff attorney I worked with at ACUS. Sorry about that, Emily. Kasia, some things get stuck there, but maybe presented by under other sources of law rather than by other sources. Any other comments that anybody has here? Jeff, is this a new hand raised? No. And Noelle, is your hand with additional comment?
Nope, sorry, lowering now.
Okay. All right, then let's go to paragraph 3. I wonder if we have an older draft, Kasia.
No, I'm looking at it now. I'm really sorry about that. There was only a couple of things that were off in the first page that we've already corrected, and I see a couple.
Because I see the beginning of this paragraph is different.
Yeah, I'm not sure what happened, but I will correct this right now. Again, apologies, everybody. So Carrie, I see that you had removed none to.
I think you could say neither here, because there were just two sources, neither of these documents. And then after the detail, make the period a comma.
Yep. Yeah, I got it. I'm so sorry.
the end of this paragraph is different as well.
I'm going to go through and make these changes right now. I'm really sorry, everybody.
Well, while she's doing that, please, feel free to weigh in off of the version that was circulated in advance of the meeting. If you don't have that, then Kasia will bring this up to matching that. But are there any comments on this paragraph at all?
I've got a couple of comments. One is where it's in the middle, the risk of contracting out an IGF or at least an activity closely associated with an IGF. Shouldn't that be or even an activity?
Okay, sure.
And then we've got the word heightened twice now, and I think the second one could just be such concerns may be greater.
Which line are you at?
31.
Oh, maybe, okay, yeah. Or maybe increased. But greater is fine too. Any other comments on that paragraph? Curdy?
Yeah, I was just wondering, I think I would suggest deleting in line 28, replacing maybe especially with are heightened. It just doesn't seem to me to be controversial that the risk of contracting out writing a rule is highest when you're asking them to draft the rule. Although I welcome other people's thoughts.
I would change it to is, not are, though. Because it's just the risk, right? That seems quite helpful. Thank you. Jeff?
I have something on the next paragraph, but sorry.
Okay. All right. Pushing us along to the next paragraph then.
At the very bottom line, could be one way for agencies to mitigate these concerns. Could be
Okay. Yeah.
Take out might. Mhm.
Good. Any other comments on this paragraph? Okay, paragraph that's starting now at the very bottom of the page, line 41, and then continuing over. This was, just to remind everybody, this had been, I think, largely in the form of a recommendation in the draft we considered at our last meeting, but has now, I think, as followed our discussion from last meeting, was put into the preamble. Jeff, do you have comments on this paragraph?
Yes, just the comparative advantage on 43. Offers some comparative advantage that the agency does not otherwise possess. I think you need something like comparative advantage to something, to other alternative ways of performing the function or something like that. Otherwise, it doesn't really scan very well. Whether a contractor offers some comparative advantage to other, whether using a contractor offers some comparative advantage to other, or to alternative ways of performing the function. Because you don't possess, you have to compare the advantage to something. To alternative ways of performing the function.
Performing a function, maybe.
Well, I think you need the there because you've already referred to a function.
Okay, the function, all right.
To performing the function.
The function, okay.
I don't think you need that the agency does not otherwise possess anymore.
Well, yeah, now, true. I mean, maybe, isn't this also just a restatement of what a practical benefit is of using a contractor? I mean,
yeah.
And then the next sentence is may wish to consider alternatives, which is implicit in what you have said. I don't know. I wonder if
maybe this whole thing could
part, just delete everything after and whether. I don't know whether that adds a whole lot once you've considered the practical benefits. What you don't delete it yet, but highlight that. I mean, would that do it? Would anybody be objecting to removing that?
No.
Jeff, what do you think?
I think your suggestion's a good one.
Okay. Let's delete it now. If others have comments on that we can put it back in. Elena.
Yeah, I was really kind of going to comment on that. I think maybe what you're trying to say is like versus the alternatives. Because I think that's where the comparative advantage lies, right? Like there are alternatives, but they're almost impossible to use.
Right. Well, that's
how I could take advantage of executive branch rotations, nor would that necessarily, it takes so long to get someone up to speed. Like you need them on rotation for like 2 years. And someone was like, please give me one of your employees for 2 years. I'd be like, I need them. So there's just a lot of practical challenges associated. And so the comparative advantage lies in the fact that the alternatives are really difficult. But I don't think we need to say comparative advantage. I think the point is just that it's the benefits and challenges of using a contractor versus the alternatives.
Right. So at the end of that sentence, you could say compared with other alternatives. But the reason why I was suggesting just deleting that whole part about comparison to alternatives was simply because the next sentence invites the agency to consider alternatives. So we could we could keep that in compared to alternatives and say something in this next sentence like some of the alternatives agencies may wish to consider would include, or something along those lines.
Yeah, I think something like that is a good suggestion. I mean, I also don't feel terribly strongly. I just, since you were asking for thoughts, I thought
no, this is all good. I mean, this is all good. So, I mean, we could just try this out. And Kasia, at the end of the first sentence, before the period, put in further, practically using a contract to perform a function of well, I don't know now. I'm less sure. We need, let's go ahead and let's just think of, and get other thoughts. David, do you have something you want to weigh in on this?
When I read this paragraph before any of the discussion, I took the phrase that's been deleted now about the agency does not otherwise possess to indicate that the point was that there was a comparative advantage over the agency doing the function itself. So at the point we're now at, my suggestion is to leave the text you have for the first sentence and insert in the second sentence, agencies may also wish to consider alternative
Okay.
methods. I think that's more economical language, and I believe that it captures the points that people have been making.
Okay, great. I think that's helpful. Appreciate it. Jerry?
As I remember, Carrie, this got into the preamble, having been moved out of a earlier draft recommendation, as a sort of compromise when we couldn't decide whether we needed it or not. As I look at it in the preamble, I'm increasingly of the view we don't need it at all. I would be happy simply to eliminate that paragraph.
Okay. Anybody want to speak up for this paragraph?
I think there's, I think that some, I'm sorry, Curdy, go ahead.
Yeah, raise.
I think there's something to it in that I think it's addressing the idea that this is a recurring problem, and the greater use of contractors only makes them more necessary in the future. And so, so I think especially the second sentence seems to me to be about capacity building as a solution to the increasing need to use contractors. And so I do think it's adding value. And I do think the two sentences are saying something different. I think the first sentence seems to be just in general, whenever you're making a contracting decision, consider the practical benefits and challenges. And the second sentence seems to me to be this capacity building point. So I take the point about the language being a little awkward, but I think it's important.
Both sentences are important. Okay. Jeff?
I agree with what Curdy said. I think it's important to have those other alternatives listed. I was also wondering why student interns were not included on this list. A lot of the law students I deal with in my classes get internships in agencies, and they report to me that they're assigned to work on reading rulemaking comments.
Well, it's not exhaustive. There were, I think, even some other like pulling people out of retirement that I think these seem to be what may have come through the report as the more distinctive options that agencies might in the normal course not have thought of their own, or maybe not be as quite as aware of. That is my understanding why this isn't.
Yeah, I don't think it was in the report. I think I was going to comment on that to the authors of the report, saying, what about student interns? Because I suspect that our EPA representative will confirm that they sometimes use student interns on rulemakings.
Okay, so I hear Jerry saying let's get rid of the whole paragraph. I hear Curdy and Jeff saying it adds value. Any other comments? I mean, one possibility would be to split the difference. Maybe the first sentence is self-explanatory, or you could just keep the second one, I suppose. I don't know. I don't know if there's strong views. If there's no strong views, I suppose, to take it out, then let me ask if there are any others who think we should just take it out. All right, so I guess by default we'll keep it in, and then the final paragraph. I had just a couple of changes here I was going to suggest, but Kasia, is this up to date?
I believe it is now.
Okay. One was where it says this recommendation. Well, no, I don't think this. Oh, yeah. Okay. Where it says recognizing that agencies need vary enormously, it, meaning the recommendation, identifies a range of legal, ethical, prudential, and practical considerations. I'm not sure the recommendations really identify those considerations as much as respond to them. That would be my suggestion here, would to say it responds to, but, or addresses something along those lines rather than identifying. And then
I think addresses is the better choice, yes.
addresses, yeah. And then certain rulemaking activities on line 57, maybe better to say rulemaking related activities, keeping more with, but here I also had a question again about tasks or functions, and I think I'll bracket that until we finish with any other substantive comments. Are there any other comments on this final paragraph in the preamble? Jeff, is your hand for something new?
Whenever you have a chance.
Matt, yes, you had a comment. Mm-hmm.
At the last sentence, which says that agencies, that the recommendation is intended to ensure that agencies achieve an appropriate level of transparency and accountability. The recommendation does things beyond that unless everything else is subsumed under accountability. The other thing I would say is if you sort of look at what the recommendation addresses, it addresses ethics. I don't think you achieve an appropriate level of ethics. You either act ethically or you don't. So those are my comments on the last sentence there. I just think it's incomplete, maybe at best. I don't have language, but
is it a sentence that's necessary? Is it really adding much? You know, I do think there's a if it's not adding much and there's a risk that it's going to be incomplete or leave something out, it may be better to forego it. Anybody have any objections to deleting this? Okay, I think does that take care of it, Matt, satisfactorily for you? You were muted, but I take it that's a yes.
If that's fine with the committee, it's certainly fine with me. It does address,
Sure.
The answer to your question is yes, though.
It does address that concern. Okay. Are there any other comments now on the preamble overall? Anything that we did not take up that we should? Maybe it's even, I do think we want to circle back and find a place to put that quoted passage defining what a closely associated intergovernmental function is. So Jeff, I don't know if that's your point, but why don't we focus on that, and then I'll come back to you, Jeff, for your point. Do we have a quote for where do we first introduce in the preamble the idea of closely associated? Okay, it's line 22 on the next page, I think, Kasia, a little bit farther down. And maybe at the end of that sentence, footnote added at the end of line 23. And I don't know that we need to actually, unless anybody really insists, I think we could just insert a footnote there and a bracket in the footnote saying to be added, quoting the definition or the description in full of closely associated to an IGF. Will that meet that concern? Anybody have any objections or concerns about that approach to closely associated? I think
What is the-
Curdy, you
what
had
is the- what is-
raised this point
What is the
earlier.
language? What is the language from the policy letter?
Who was it? Was it Bridget or Rachel? Rachel, I think you had quoted from that passage before. Can you remind us?
Yeah,
of
let me
that
pull it up.
language?
Can I put it in the chat? Would that be okay?
Sure. I think, and then I'll read it, so it will be in the record. The quoted language, and this is coming from Rachel. Where is this coming from?
I just cribbed that from the report, but Bridget, correct me if I'm wrong. I think it's directly from the policy letter, right?
Yeah, if it was a quote in the report, that's right. If it's not a quote, we can.
The table, it's table 1 in the report, which is the table which I think is copied directly from the report, or from the letter.
And the quoted language would be support for policy development, such as drafting policy documents and regulations, performing analyses, feasibility studies, and strategy options.
I'm looking to confirm it's a quote, but it'll take me a moment to pull up the document.
There's a verb missing before strategy options, but that's.
Okay, I'm just going to paste the quote from the policy letter. It looks very similar, if not the same as what Rachel posted, but this is from the policy letter itself.
Okay. And I will read that now, and Kasia can enter that into the draft. But this reads, support for policy development, comma, such as drafting policy documents and regulations, comma, performing analyses, comma, feasibility studies, comma, and strategy options.
Doesn't it seem like there's a verb missing before strategy options?
Is there a longer string from which this is extracted?
I'm going to send you the citation now.
Okay, and the citation is 76 Federal Register, 56227 and 56234.
Probably should be developing strategy options.
It's part of a table, so the language is truncated, but that is the full language, support for policy development. This is work that's closely associated with IGF.
I mean, maybe the way to make more sense of it would be to bracket out the first and, the and between documents and regulations, right? It's such as drafting, or well, no, maybe not, performing analyses, feasibility, or putting an and actually after regulations in brackets. Would that work?
I think it's okay the way it is now with the putting developing in brackets there. It seems to scan.
Okay. Well, we can, well, it leaves no gerund in front of the feasibility studies. That's why I think it really is, and performing analyses, feasibility studies, and strategy. Well, yeah, and well, maybe we put the and in between, yeah, right where you're at, Kasia, between analyses and feasibility studies in brackets. And then, yeah. And this comes from the Federal Register, again, on September 12th, 2011, 76 FR 56227, 227, and then 56234. Okay, any other concerns or comments about the insertion of that language as a footnote there? Okay, seeing none. Jeff, you had another comment about preamble, and I invite any other comments about preambular issues.
I just wanted to make sure we put in a reference to the earlier recommendation. At the appropriate 85.2.
Okay.
Paragraph C.
Any suggestion on where that might go?
Let's see. How, maybe after the first sentence in the second paragraph, or even the first sentence of the recommendation. CEG.
I think I like the idea of after the first sentence in the second paragraph.
Okay.
And that could be a CEG as well.
You're talking about here, right, in line 11?
Yes.
Okay.
Okay, while she's entering that, Bridget, you have a comment?
Yeah, I guess, I mean, putting the cross-reference in makes a ton of sense to me. And if someone was to pull that cross-reference up, of course, they would see the different approach to the drafting function here. And so I guess I just want to pose the question for the committee of whether they want to be express about the fact that they're walking away from that prior recommendation with respect to drafting, or whether they want to be silent on it or something. But if someone was to look at it, they would find a much stronger position on the drafting function in that old recommendation that's referenced here, but not, we're not coming up with distinctions or anything to explain the daylight between those.
But it's not totally comparable, right? That was about regulatory analyses, but
It's, I would say regulatory analysis is subsumed within the scope of this project, though. I mean, we certainly talked about the use of contractors and to produce economic analysis. Yeah.
But isn't that within the definition of the IGF?
No, all of this is closely associated, right? So
I mean, what's the definition of closely associated? It would fit in there, wouldn't
it? It would, but so would all the rest of drafting. So in the recommendation, and perhaps I misunderstood 85.2, but I thought that what you were saying 85.2 said was that there was a suggestion that drafting of regulatory impact analysis by contractors was to be discouraged, and maybe it's best if you just reread the language.
Employees, not consultants, should draft them.
Employees, not consultants, should draft, right? So, but here we're
not contradicting that. We're not contradicting that, are we?
I mean, well, I'll let others speak to this.
I don't know. We're not. I don't see that we're overriding that in any way.
I think our new recommendation 8 is consistent with that now, isn't it?
Okay, Curdy, you have your hand up.
Yeah, I don't think so. I think I agree with Bridget's point, which is that if we include this reference, and if somebody looks at recommendation 85.2, they might say recommendation 85.2 says employees should draft, not contractors, and if and contractor involvement must be disclosed. And it's not inconsistent. This recommendation isn't inconsistent, but it is different in that it doesn't say that employees should draft in those unqualified terms, and it also doesn't say that it should be disclosed in those unqualified terms. So it's taking a much more lenient position. It might be that it's open to interpretation about whether members of this committee think that the 85.2 approach is better, and this does not foreclose it, but it is certainly less strict. But I think all of that said, to the initial point that Bridget raised, which is, does it matter if anybody reaches that conclusion, I think including the reference is helpful, because it is a related kind of prior recommendation. And I also think there's nothing wrong with being transparent about the fact that there are two conflicting approaches and that potentially we are treating regulatory impact as much more significant than drafting of actual regulatory text. And I think if there's nothing wrong with being transparent about that potential inconsistency here.
I guess the one thing I'm struggling with, I mean, I think I agree with almost everything you said, but I'm just struggling with where is the conflict or the inconsistency? We're recognizing that the contractors report says in some agencies, engineering staff are having a contractor help with drafting. We know that. We know it. We're not endorsing it, but we're not really speaking to it. We're saying, come up with a written policy. It's something in some ways different. You could even say it's supplemental to what's in 85-2, if anything. But maybe I may be wrong about that. And obviously it's up to the committee to decide which way they want to proceed. I have Emily in the queue next.
I mean, I agree with Curdy. And I mean, my read of the discussion in the committee has been that we're not saying anything because we think it's fine. I mean, I don't see how we can describe a phenomenon that I mean, as we've discussed, we didn't really expect to find, and then adopt a recommendation that says absolutely nothing about limits on it, and then think that we're not at least tacitly approving of it.
So do I hear a suggestion that we should entertain a statement saying we hereby disavow this portion of recommendation 85-2, if that's...
I do not support that.
Well, I mean,
one thing I will say is I find interesting the language that has been read. I think this, a preference for employees doing the work might be a better way to phrase what I have been advocating for rather than a prohibition on contracting out. I mean, to me, it affirms the same principle, but does so in maybe a way that is better. But I do think that there is an inconsistency. And I mean, I'm personally, from what little I've heard, and I don't think I've heard nearly enough, I'm inclined to think that the prior recommendation is superior on this point.
And just, I want to remind everybody, in the spirit of Nick Perillo, who can't be still with us, of that paragraph on page 2 that speaks to the heightened risks associated with having contractors draft. Isn't that, Emily, essentially providing the statement about a preference for employees? Or should we revisit this language here?
I mean, I don't think it is the same, but
Okay.
I also think I don't think I've persuaded people, so
Okay.
I'm not inclined to continue pressing it, at least not here.
Okay.
Isn't recommendation 8?
Jeff, yeah,
Isn't
go ahead.
recommendation 8 pretty consistent with the earlier one? I mean, can you go back to number 8 for a second? And that's sort of along the same lines as the disclosure part of the earlier recommendation, because I would think that working on a regulatory analysis document fits into an activity closely associated with an IGF.
With the language we've just quoted, it certainly does. Jerry, you're next.
So I think I agree that there's not a direct inconsistency, but there's an implicit difference, it seems to me. And I would not be in favor of explicitly disavowing 85.2, because I think maybe 85.2 was appropriate in 1985. And what we're doing now is appropriate in 2022. We've had an additional 37 years of limitations on government employment, which has resulted in much more widespread use of contractors in all sorts of functions. And attempting to reverse that trend in an ACUS recommendation, I think is really lunging at windmills. So, you know, I think I would just leave it. There is an implicit difference in tone with respect to approving and disapproving the use of contractors. But I'm not sure that's not appropriate given the difference, you know, the 37 years difference in context.
Gertie, back to you.
Yeah, I think all I was going to say is just that recommendation 85.2, although limited to regulatory analysis, says both that agency employees should do the drafting, and where they are doing the drafting but relying on a report, that has to be, or not, you know, should be publicly disclosed. So those are two strong statements about the role of contractors and the transparency required. And our recommendation right now doesn't have the first statement. It doesn't expressly discourage the use of rulemaking or the use of contractors in these IGF or closely related functions. And it also doesn't have a categorical requirement of disclosure, because it only asks that agencies consider disclosing. So on both fronts, it seems to me weaker. And there might be, for the reasons just given, reasons for that. But I think it's hard to deny that stepping back and just objectively reading the two documents, that this one has recommendations or a view that is not clearly against or doesn't express that preference for agency employees and doesn't express that preference for transparency.
I think Carrie pointed out that the second part of the earlier recommendation was really required by law anyway, because the agency is relying on the consultant reports. We're not talking about the agency relying on anything that the consultant does here. So I think it just restates the law as it was and the law as it still is.
Yeah, I don't want to get too into the weeds in FOIA, but my understanding of it is that there's a consultant exception to FOIA, and or at least until the Supreme Court takes up that circuit split there is, and then also that the deliberative process privilege might have covered those documents. So I'm not sure I agree with that last point, but I understand it.
Okay. So let me ask if there are any suggestions from anybody about this additional footnote citing 85-2 in other than just citing it there, or maybe it shouldn't be cited there, but if it is cited, is there anything else that should be said there? Or any other language to add or suggest? I will say that one of the difficulties with figuring out how to explain these differences might be challenging, because again, I read 85 dash what is it, 85-2 to get into this perhaps philosophical question about what does it mean to draft. The point in 85-2, it's very clear, is that the agency should have ultimate responsibility. Does that mean that a consultant can't do anything related to, the words that end up in the regulatory analysis document, and then how do we have, is there attention, is there not attention, may hinge on what somebody means by drafting. And I think it was, I forget who, maybe Elena, who said earlier, we have to figure out what drafting means if we were to go down this road. Bridget?
Yeah. So, I mean, it sounds to me like the position of the committee might be that the language of 85.2 is not something that the majority of this committee supports. And so if that's the sense of the committee, I don't know why you wouldn't memorialize that. If folks are persuaded that times are different and that means that our legal interpretation of IGF, should be informed by the practicalities of modern government administration, then that can be a finding of the committee. I guess to me, there's just sort of this latent disconnect here that if this committee wants to walk away from 85.2, it sort of seems to me like it can. I don't know why that would be, if that's where the committee is, I don't know why you wouldn't record that sentiment.
Maybe the committee isn't there. I'm not hearing anybody saying yet anything that should be added other than this citation to 85-2. Dick Pierce.
I'm fine with the way it is right now, and I don't think we need to, I mean, frankly, I don't know enough about 85-2 to know whether I agree with it or disagree with it. I mean, Carrie, you just provided one interpretation of 85.-2 that I agree with completely. And yet I certainly can imagine other interpretations that I would disagree with. And I don't think, I don't feel comfortable that I know enough about 85.-2 to say that this is inconsistent with it, that we disagree with it, that there are two different recommendations made at different times in different contexts. And I'm just not comfortable saying, oh gosh, we embrace it or we oppose it.
David?
Would the problem be solved by using the signal CF instead of SEE?
Any objections to CF instead of CEG? All right, we are close to our ending time for today's meeting. I am open to any motion if anybody wants to make it, but I'm sensing that we might benefit from even a short third meeting, perhaps, but I'm open to a motion if we're ready to approve this. I do think there's still one kind of more style matter, but it may have substance to do with this definition of function in the recommendation and when to say function and when to say task or function. So there may be some value in having a little bit more time to discuss that. And we've heard that OMB might have some further comments on recommendation, what is number 10. So I think it may be better to move to a third meeting, but Elena, do you have comments?
I kind of raised the whole task thing to begin with. I have been thinking about it during our other discussion, and I recommend function. Not all contracts would necessarily have a task. I don't think we want to limit ourselves to tasks. I don't think we want to get into the realm of potentially using a term of art. I think function is preferable.
Sufficient. Okay.
Yeah, I think it covers what we're trying to get at without introducing potentially challenging terminology issues. So
could we just quickly look at recommendation 3 again, very quickly, because there the word was duties, and see if we could replace that duties with function there. What do you think? Would that work there, or should we keep duties? Or assign functions seems to work.
I mean, I think functions works. I think duties is potentially fine there as well, because this one is more about, to me, reads more like about the day-to-day tasks, or no, tasks again, but the day-to-day responsibilities of the contractor, which duties works with, but I think functions is fine as well. So in terms of going for consistency, function is probably good.
Okay.
Because I think this just came up as part of the, like, let's use consistent language.
Right, that would be consistent, and then removing where we have tasks but let's not decide that right now in the last minute or two. We'll leave this as in this form, but if others have thoughts about tasks or functions, anything else, we will certainly have another opportunity to revisit. I hope that everybody feels like we got a lot accomplished today, and that we are well along on what seems to be close to being ready for a committee vote, which we can do on our next meeting, which is, if I recall correctly, it is on April 25th, Monday, April 25th at 2:00. The meeting is slated for 3 hours, 2 to 5, but doesn't mean we necessarily have to meet for 3 full hours. We are at the end now. I want to thank everybody for your time and your participation and your thoughtfulness as we work through these issues. Matt, do you have any closing comments for us at all?
I think the committee's in a very good place thanks to your leadership.
Thank you. And with that, I think we will adjourn for today. We will see everybody on April 25th at 2:00, and wish you all the best until then.